Good morning, everyone. As Sambhav Initiative has said, this will be a last lecture on a criminal subject, and therefore I will cover appreciation of evidence in criminal trial. As usual, would like to start with some slides. So, let me start it, just a minute. Yeah. You have to allow me to share slides so from here. My screen is visible?
Yes, sir. Your screen is visible.
Entire screen is visible?
No, sir. Your entire it's not showing your slide. So
Now?
Yes, sir. Yes. Now it's visible.
Okay, fine. So this will be a last lecture on a criminal trial, a subject of criminal trial or a criminal law, and we'll cover appreciation of evidence in criminal trial in couple of minutes. Before I start the subject, I would ask every one of you, how much of you are aware about this story of a Panchantra? Blind man, 6 blind men and an elephant. I hope majority of you would be aware about this story. It is very interesting. The law, and more particularly appreciation of law, has something similar to this story. See, when 6 blind men touches the elephant, every person is touch or reach to the different part of the elephant, and therefore each one of them are of the opinion that elephant is either a fan or a spear or a wall or a rope or a tree or a snake, but elephant is elephant. It is one thing, and every blind person touching at a different part of the elephant is of the opinion that elephant is of a particular nature. So practically this is the reality of not only criminal law or any other law in our country or anywhere in world, but it is also reality in the life. As we apply this to people around the globe, we see that it is not the people who are blind. They see issue very clearly, but they see these issues through the lens of their position, interest, belief, sales, production, finance, logistics, HR and religion, so far as business houses are concerned, or culture, custom, ego, bias, competition, and so on, so far as general public is concerned. And so far as criminal law or any other law is concerned, every person is interpreting the law as if it is only in their favor. Thus, using the elephant metaphor above, the question is, who is functioning blind? Who is appreciating evidence is most material. A lawyer or an accused will appreciate, or will try to appreciate the evidence in his favor to see that he is acquitted. Whereas a victim or complainant would like to interpret the law or appreciate the evidence in his own favor so as to convict the other side. But the basic thing that law is law, evidence is evidence, it is to be interpreted in accordance with law and statute and as a prudent man. We will try to understand how to appreciate evidence. But before coming to the legal facts, we have to understand this story also, that every one may have a different say for particular fact, but ultimately it is your mind or your choice. You cannot please everyone every time. Whatever you do, there will be a people who will criticize you. Similarly, whatever you, the way in which you appreciate the evidence, somebody may criticize it, but you have to appreciate the evidence in accordance with law. Thus, now appreciation of evidence is a matter of experience and knowledge of human affairs. It is a delicate task to be carried out by judges who weighing evidence and drawing inferences. Each case presents its own peculiarities. Common sense and skill are also part of the tools. Appreciation of evidence is a term used in Indian law to refer the consideration or examination of the evidence by the court. It involves weighing the credibility and reality of the evidence presented in the case. So basically, appreciation of evidence is not a physical thing, but it is a matter of experience and knowledge of human affairs. And it is very delicate task. Generally, it is to be done by judges for deciding a case either in favor of the accused or against the accused. And so far as Indian law is concerned, appreciation of evidence is considered for examination of evidence by the court. But before the court appreciate evidence, it is for the parties to realize that what is the basic requirement of particular evidence to be produced before the court, which court can appreciate either in favor of the victim or against the victim or against the accused. So unless parties, litigants, their advocates do not appreciate the evidence, do not understand that which evidence is material, the court has a difficulty in arriving at particular conclusion or decision, and this results into multiplication of litigation and acquittal so far as criminal cases are concerned. So before producing any evidence before the court, it is very necessary for all of the litigants to be careful and to appreciate the evidence on their own so as to cut short the lengthy trial before the court. I will give you one simple example. If somebody wants to file a complaint regarding murder, the basic requirement for an FIR regarding murder would be there must be disclosure of death of a particular person, and there must be a dead body presence or at a particular place or at somewhere dead body means fact of death is also equally necessary. If there is no evidence regarding death of a person, then that FIR could not be considered under 302 of IPC. So a FIR is merely a piece of paper, but what contents of FIR would be relevant to consider that what is what. Law is basically logic or concept based upon cultural, social, and geographical necessities and social values. Though it is codified, it is not static. So the interpretation of law and thus appreciation of evidence would also not remain static forever. However, appreciation of evidence is both art and science. It is art because it is a skill acquired by continuous practice and through real-time experience of an individual. Somebody's mic is on, please. So many other voices coming. Whose mic is on? Everybody is requested to mute their mics. Please. So, appreciation of evidence is art, because skill acquired by continuous practice and through real-time experience of an individual. Whereas it is science also, because it is a systematic approach adopted as per basic scientific proposition. So far as legal system is concerned, it is adoption of systematic approach under the governance of certain rules framed either by the legislature or under the due adherence of the court's verdicts. So practically, while appreciating evidence, one has to take care of two things. One, legal provision and court's verdicts, how to consider or how to appreciate particular evidence. And after that legal knowledge, the real-time experience of individual would be equally important to realize that what is what. When witness appears before the court and start disclosing particular fact, his personal details and personal behavior is equally important, whereby one can understand that whether he is telling the truth or not. Appreciation and evidence. When we are talking about appreciation of evidence, we must realize that what is the difference between appreciation and evidence. The word appreciation, according to Black's Law Dictionary, means to know or to understand or to realize. Unlike normal English uses of the word appreciation, which means admiration, the word appreciation must, for all purposes, is a distinct word in the legal application or rather sense. So the word appreciation, which is used in day-to-day life, has a different meaning, and when the same word is used in law, and more particularly for appreciating the evidence in legal proceeding, the meaning is different. In general language or in general uses or in day-to-day life, appreciation means admiration. Day in and day out, many a times we say somebody that I appreciate you, I appreciate this, I appreciate that particular thing. That appreciation is practically admiration of particular person, fact, or physical thing, or some concept or something. But appreciation of evidence, when we use this phrase, the meaning of appreciation is little bit or somewhat different. When the word appreciation is used in a phrase with evidence as appreciation of evidence, then the word appreciation means to know, to understand, and to realize. So knowledge, understanding, and realization of particular fact would result into appreciation of that evidence. So when some evidence is produced before the court, before it is proved before the court, it is prima facie evidence. But when it is proved on record by deposition of a witness or by producing a particular document, then it is to be appreciated that yes, particular evidence discloses particular fact, and thereby somebody can be held responsible as if he has committed particular act, or whether he is responsible for particular liability or responsibility. Whereas word evidence has a simple meaning. As per Tomlin's Law Dictionary, evidence means an inference logically drawn as to the existence of a fact. It consists of proof by testimony of witness on oath or by writings or records. The key word in the said context refers to inference to be drawn logically, means that by use of reasoning, conclusion or derivatives must be drawn. Though it may seem to be typical or clumsy, but it is very simple. That again, I am saying, taking the same example, that a complaint and FIR would be piece of paper unless there is proper disclosure of commission of particular offense as required under the law. As required under the law means, if you want to file a complaint for murder, there must be disclosure of a death of a human being. And even if we are not aware about the nature of death or who had committed death, there must be some basic facts that where dead body is lying and how we came to know about it. So complainant can simply say that he has seen a dead body lying at somewhere, someplace or particular place, and it prima facie it seems that he has been killed by somebody. Then after that piece of paper, complaint becomes FIR for a murder, which entitles the investigating agency to investigate and to arrest somebody and file a charge sheet or report against him before the magistrate. Then he would be tried and maybe sent behind the bar if his involvement and offense is proved as alleged by the investigating agency. So a piece of paper disclosing particular fact in particular manner becomes an evidence, an instrument which give a motion to the criminal trial. But within the same case or same example, after lodging an FIR for murder, again, the evidence and appreciation of evidence would come in picture. When investigating agency find out the cause of death and nature of human body who is alleged to be killed, because killing is different than death, simple death. There would be death in killing, but every death may not be by killing. There may be a natural death. So now cause of death is required to be disclosed on record of the case. It must be proved on record. And then this part is appreciation of evidence that yes, there is a death of a human body, human being, his body is found, his body is examined. The cause of death is unnatural, by poison, by injury, by sharp cutting instrument, or by firearm, or some other cause of death, which is not natural in course. So unless doctor certifies that the cause of death is not natural, or in other terms, if doctor who performs postmortem note of a dead body of a human being for whom there is a complaint that he is killed, found that the death is natural, heart attack or failure of organs or any natural cause, then that paper document, the postmortem note, needs again appreciation initially by the investigating agency, an advocate for the prosecution or victim, and during trial by the advocate of the accused and the accused, and both would try to prove it differently. The investigating agency may try to prove that cause of death is not natural, whereas accused and his advocate would try to prove that cause of death is natural, or injuries or cause of death are not such which can connect the fact of death with the accused so as to punish him for committing a murder. So this is called appreciation of evidence. The physical FIR or physical document may be there, available on record, either with the investigating agency or with the court, but unless that evidence is properly appreciated by someone, more particularly court, it cannot be said that there is an evidence to confirm that accused has committed particular offense so as to punish him for that offense, because punishment would be curtailing his liberty and therefore it is a serious matter. So before punishing someone, there must be proper evidence to confirm that he has committed, he and only he has committed this crime. And this confirmation would arrive by appreciating the evidence produced by the prosecution or the investigating agency before the court. So there is a difference between simple evidence and appreciation of evidence. Simple evidence means evidence in physical manner, FIR, weapon, physical weapon, if seized and produced before the court, postmortem report or note or injury certificate or any other document, and oral deposition of the witnesses. Those are evidence. But whether those evidence proves anything against the accused, that process is called appreciation of evidence. And unless evidence is properly appreciated, there may not be conviction. Therefore, before court appreciate the evidence to confirm the commission of crime by the accused, it is very much necessary for everyone victim, his advocate, complainant, investigating agency, prosecutor, all has to appreciate evidence on their own before leading it, before adducing or producing it before the court in a trial. And same evidence would be tried to be appreciated or tried to be stated in different manner by the advocate for the accused, so as to prove, so as to believe that that evidence is not enough to punish the accused. So there is a, as I said, there would be a story like elephant before the court. Everyone would be saying that it is different in nature. It is for the court to decide that it is elephant and not other animal. In law, more particularly Section 3 of Indian Evidence Act, the word evidence is defined, stating that evidence means and includes all statements which the court permits or required to be made before it by witness in relation to matters of fact under inquiry. Such statements are called material evidence. And all documents, including electronic records, produced for the inspection of the court, such documents are called documentary evidence. So basically, there are two types of evidence: oral and documentary. Oral evidence means deposition of witnesses on oath before the court, which would be subject to cross-examination by the other side, and documentary evidence. So documentary evidence, as I have said earlier, that appreciation of documentary evidence is very simple. That is to ascertain that what it provides for, or what is disclosed in that document. If postmortem note does not disclose the cause of death being unnatural or by the injuries which might have been inflicted by the accused, thereby If postmortem note simply discloses that cause of death is natural, then though it is an evidence, that is a postmortem note, a physical evidence, and though it confirms the cause of death of a victim, a human being, the appreciation of evidence confirms that it is not sufficient to convict the accused because cause of death is natural. There is no reason to believe that the injuries were inflicted by the accused which resulted into death of a human being. So similarly, in any other type of document, FIR or agreement or any other document, understanding, memorandum, what is written and signed and agreed by the executor of such document is material. The existence of document alone is not sufficient and material to prove certain thing. Similarly, and this is in particular appreciation of evidence that whether particular document proves something or not. Similarly, so far as statement of witnesses are concerned, it again requires a lengthy consideration or lecture, but so far as appreciation of evidence is concerned, the basic fact that oral deposition of a witness on oath before the court and after his cross-examination by other side would result into a material evidence, oral evidence of a witness. But again, its appreciation would be based upon his nature of statement before the court on oath and how he stands in cross-examination. So if he becomes hostile or if he do not support his own statement in cross-examination, or other side is able to prove something different than what is stated by the witness during his examination in chief, then many a times entire oral evidence of the witness results into nothing but a futile exercise of recording his evidence on record. Therefore, oral evidence is, though not equally but more relevant in any trial, it is always subject to cross-examination by the other side, and therefore unless witness is able to stick to his statement both in examination in chief and cross-examination, his deposition may not be worthy or enough for either convicting the accused or to confirm any liability or responsibility so far as civil matters are concerned. Again, this process is called appreciation of evidence. So appreciation of evidence is a concept rather than any physical thing, though evidence is a physical thing in form of either in form of a statement, oral statement recorded by the court on record, or documents as referred earlier. So this is simply a pictorial slide to realize that what is evidence. Oral evidence and documentary evidence. Oral evidence means all statements which the court permits or requires to be made before it by witness in relation to matters of fact under inquiry. So what is material so far as oral evidence is concerned? Statement in relation to matters of fact under inquiry. So if I am making all other statement on oath before the court, but not disclosing particular fact regarding the incident or issue for which trial is being conducted by the court. Say for the trial of murder, if witness comes in the witness box and does not confirm anything or does not prove or disclose anything regarding death of a human being by an accused, then no doubt there may be other witnesses like production of a witness like in whose presence investigating agency has investigated and sees the weapon alleged to be used in the offense or any such other physical thing. Those witnesses may not be aware about the actual incident, but then they have to support the story of investigation that yes, they had witnessed it. But so far as main issue is concerned, unless there is a disclosure by the witnesses in statement regarding death of a human being and cause of such death connected with the accused, his deposition may not be relevant to convict the accused. So, after reading that deposition, making it in favor of the accused or not in favor of the accused, that process is called appreciation of evidence. And so far as documentary evidence is concerned, all documents, including electronic records, now are produced or for the inspection of the court. So if anything is produced before the court, which court can inspect and gather some knowledge or realize about some fact that yes, X has agreed to certain terms with Y, or X has entered into some transaction with Y, or so on. Whereas in criminal matter, whether that document discloses particular fact like cause of death in postmortem note or injuries, nature of injuries and out its result in injury certificate, and similar such documents, scientific report, then confirming whether particular substance is present or not, or so on. There are several different type of evidence depending upon different type of cases. Now, what evidence do? Evidence determines how the parties convince the court about the existence of facts according to the provision of the substantive law, which would establish the existence of rights, liability, or disability, so far as civil matters are concerned, and involvement or innocence of the accused, which they assert to prove or deny in the proceeding. It is well known that the proof is the fact or result of evidence, while evidence is the medium of proof. So, when some existence of some fact or something in accordance with provisions of substantive law is disclosed in proper manner before the court, and such disclosure or such fact would establish the existence or non-existence of someone's rights, liability, or disability, so far as civil matters are concerned. And in criminal matters, either involvement or innocence of the accused. This is called evidence. And to ascertain this fact, the assertion of such particular fact or particular evidence, whether it is proving something or establishing something or not, that process is called appreciation of evidence. And it is, as it is well said, that evidence is the medium of proof. Unless that evidence proves something, it is only physical medium. So the proof of proving something, that proof is the fact and result of the evidence. And considering that whether particular physical evidence, medium of proof, that is documentary evidence or oral evidence, whether it proves something or not, that process is called appreciation of evidence. The significance of appreciation of evidence in legal proceedings is like a nonce in the dispensation of justice. The judges has to consider the testimony, both oral and documentary, in order to conclude without bias on the system of reasoning so as to anchor the facts to harbor of truth in order to demonstrate, make it clear, or to ascertain the truth of the very fact or point in issue on either side. Thus, appreciation of evidence is practically a basic issue or concept or concern in jurisprudence, in either of the jurisprudence, civil or criminal. And it is very much necessary for dispensation of justice. Because practically the parties have to, and court would have to find out the fact and nothing but the fact, the truth and nothing but the truth from the fact which is disclosed before it by either side. So as to ascertain that particular fact or particular evidence is confirming particular point on issue or not. Again, this process of examining the evidence for coming to the conclusion that such evidence proves certain thing, that process is called appreciation of evidence. Appreciation of evidence is one of the foremost ways to consider credential of the evidence brought by the parties in a proceedings who produce their respective theory of right, liability, or disability so far as civil matters are concerned, and in criminal proceedings, either involvement in commission of crime or innocence by the accused. And it is the basic thing to be taken care of. Then what is the basic concept of marshalling and appreciation of evidence? Marshalling means unless you marshal the evidence, unless you take care of the evidence, you can't appreciate it. The marshalling of evidence is not the repetition of what a witness said, but the critical grouping together of the relevant statements of particular witnesses for and against a particular fact. So, no doubt we are living in democracy and therefore crowd is able to control so many things. Not if control and lead certain things. So far as appreciation of evidence in majority jurisprudence in the world, barring few, confirms that there is no need of repetition of making the same statement by different person. Thereby, number of witnesses or number of persons are not material. None of the fact or evidence needs to disclose by n number of persons, though some of the documents requires minimum 2 witnesses to endorse that executors of the document have really executed such document in their presence. But in majority cases, there is no need to have more witnesses to prove particular fact. But then what is required? The marshalling of evidence means grouping together of the relevant statements of a particular different witnesses for and against particular facts. So if at least more than 2 witnesses, more than 2 or minimum 2 are enough, but more than 2 does not mean infinity. 2, 3 or 4 witnesses, if are saying the same story regarding commission of crime by particular person, and if there is no contradiction in their version, or if it is clear that they are otherwise not interested against the accused to see that he is convicted because of some other bias or some other reason, that deposition or the disclosure in their deposition, facts disclosed by them, if it is grouped together, then it becomes a relevant statement to confirm particular thing, commission of particular thing, or confirming the typical particular action by such witness or by accused, and then it becomes the evidence on record. But it is the skill of picking up various pieces of evidence on a particular disputed point and putting them together. It is not so easy. It requires certain skills. Reading of entire record at a time, or even if it is one after another, then making a note and then making it clear that what is said by different witnesses for particular fact or issue, and what is other physical evidence, either document or other, is available to prove that fact. A judge must have clear picture of various disputes, points regarding which the evidence has to be marshaled. So, therefore, in criminal cases, charge is framed before initial starting of criminal trial, and so far as civil matters are concerned, generally issues are framed so that everybody is aware that what is to be proved on record. Appreciation of evidence means assessing the worth, value, and quality of a particular piece of evidence. And that evaluation decides the fate of the case. That process is appreciation of evidence. Evaluation of evidence, or in regular term, it is appreciation of evidence. So, what facts we are, since long we are talking about some facts and some issue before the court. So, what the fact that required to be proved before the court, or which is to be considered in any legal proceeding? There are three types: facts of which evidence can be given. If no evidence can be given for proving particular fact, then there is nothing on record regarding that fact. But if any evidence can be given that yes, X has killed Y, or A has executed a document in favor of B, wherein a document with signature of A is physically available, and if that is proved on record, that is called fact, for which evidence can be given. In case of murder, if cause of death or weapon or something is found, and if it is proved on record, for which evidence can be given. Fact in issue: any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, or involvement asserted or denied in any suit or criminal proceedings. That is called fact in issue. So, existence or non-existence of any right of any particular thing, and which is confirming any right, liability, or involvement, and so on. It would be considered as a fact in issue. Whereas relevant fact means one fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of statute relating to the relevancy of facts. So if something is connected with some other point or issue, and if that connection is properly proved, then it is said relevancy of fact. And what are the basic rules of evidence? The basic rules of evidence are rules rule of proof beyond reasonable doubt. Something is proved beyond reasonable doubt, means there is no doubt about that it. Thereby, see, when postmortem note confirming that killing is by consumption of poison or the cause of death is poison, and if that postmortem note is proved on record by proper production and by deposition of medical expert, a doctor who has performed postmortem note, or either both or any of them, the expert of forensic science who confirms that the cause of that the poison is found in the dead body of the victim, and that the cause of death is that poison only. So it is a proof of rule of proof beyond reasonable doubt. Then there may not be any doubt about it. Then there will come rule of probability. Something is proved, disproved, or not proved. We consider the same example, that cause of death is, if it is found, that cause of death is by poison. But whether who has administered that poison, whether that poison is given by the accused or it was consumed by the victim accidentally, or it was because of some consuming something accidentally, which results into poison, death because of poison in that substance. So these different reasons for consumption of poison by the victim, manner and reasons, would result into consideration of rule of probability. That is, probability is there that administration of poison or consumption of poison by the victim may be either by the accused, whether he has given him with some food, or if there is no evidence, or there is clear evidence that it is consumed by victim on his own and there was no role of the accused. So that probability is also there so far as evidence recording or adducing evidence is concerned, and thereby while appreciating evidence, and therefore it is called rule of probability, that particular fact is proved, disproved, or not proved. If proved, probably prosecution may not need to examine other witness. If it is not proved or disproved, there is a difference. But if it is not proved by particular evidence, then investigating agency may call for other person to depose and to prove the fact of such document. But during the appreciation of evidence in the form, the way in which deposition is recorded by relatives of the victim or other witnesses and medical evidence, when FIR is talking about death by poison, but during evidence, if it is found that the death is not by poison, but the cause of death is something different, then that fact is not proved or disproved at all. In that case, investigating agency may require to examine somebody else. Then come rule of presumption. Something may presume, shall presume, or conclusive proof. So far as presumption, rule of presumption is concerned, some statute, legislature provide the rule of presumption. The simple or normal known example to all of us is a presumption under Negotiable Instrument Act regarding holding of the check, that is negotiable instrument, wherein if somebody is holding the check, then it is presumed that he received it by the executor or by the person who has endorsed the check for making some payment, making payment of his dues. It is to be presumed. There is no need to prove beyond it. There are some other rule of presumption in different statutes. If particular person is called for to disclose particular fact and he failed to disclose it or to produce particular document, then there will be presumption that such disclosure or such document is against him, and thereby the issue or fact for which such evidence is called for, would go in favor of the person who has called upon such fact. So there is rule of presumption. Something is, though it is not proved on record, it is been presumed. And that this probability and presumption both are, again, concept of appreciation of evidence. There is one another principle which is not much used nowadays in our jurisprudence, that is falsus is in omnibus, meaning thereby that if witness is making one false statement, his entire deposition is to be discarded. Means once a liar is always a liar, or one false statement means entire statement of the witness is false. But now this concept is not being followed so far as Indian jurisprudence is concerned. But before a couple of decades, such concept was there in use. Therefore, we must realize it, or we must understand it, that few facts are not known to the witness, and therefore, if he is unable to disclose particular fact in particular manner, or if it is so happen that the statement made by the witness is not correct, so it can be said that he lied before the court. But only because of one such wrong statement or false statement, it cannot be held that his entire statement is not credit-worthy. Therefore, the simple reason is that though we do not forget our date of birth and marriage anniversary, none of us would be probably able to recollect that what they have taken in lunch in last week or same date in last month, that is on 24th March, what was your lunch or your dinner? We may not recollect it. But we recollect our date of birth, our date of marriage anniversary if married, date of birth of our near one spouse or son or daughter or parents or loved one. Some specific instance in our life, percentage secure in last examination, grade secure in examination, school where we have studied, classroom where we have studied, college, those names, those facts we don't forget. But we may forget certain things. Therefore, many a times, if something is asked to a witness and if he is unable to disclose the correct fact on particular point, but he is able to disclose correct fact so far as issue before the court is concerned, that is the incident for which trial is ongoing or the fact for which is required to be ascertained by the court, then only because he is unable to answer other questions properly or truly, it cannot be said that his lie results into making his entire deposition useless. But many a times, all of us are under impression that if somebody is telling lie on a particular issue, then he should not be believed or he should not be relied upon. But then that process is called appreciation of evidence, which is to be taken care by the concerned judge or authority whenever matter is under trial or on trial before such authority, judicial or quasi-judicial. Then comes weighting of evidence. As I have already discussed, that n number of witnesses are not material. The contents of disclosure by those witnesses are material. What is disclosed is to be weighed and not to be counted. The number of witnesses are not to be counted. This is basic rule of evidence. And lastly, based evidence rule. Based evidence rule and rule of proof beyond reasonable doubt is almost similar. Based evidence means if we have to prove that out particular date, time, something, then we have to produce evidence regarding that. If we have to prove injuries, we have to produce injury certificate. But we can't ask court that since I am complaining about commission of crime by a sword, please believe that there is this injury is by sword. But based evidence rule is we must prove through medical evidence that there is injury and such injury is done or can be there, if not only by the sword, but probably by the sword. At least probably there is probability that such injuries can be inflicted by the sword or by some similar weapon. So that is called based evidence rule, that what is need to be proved is to be proved by some based evidence. I will give you one because otherwise all such lectures are little bit boring, but I will give you one different example. When you are going to be an advocate or when you are trying a criminal matters, now consider one example. In a given criminal case, the accused has been convicted. Thereby, he has to go behind the bar in jail. Now, he has a right to file an appeal. Thereby, he files an appeal. He is released on bail pending appeal. Now, unless appeal is heard on merits, he would be on bail. He is free. At such stage, suppose he is died, naturally or for any damn reason, the disclosure of death on record needs an evidence. What evidence? A based evidence rule. If it is unnatural death, postmortem note. If it is natural death, at least death certificate and disclosure by of his near relative that he is dead. I am saying, giving this example because in appellate court, I have came across learned advocates who argued that once our client, the accused, appellant in a criminal appeal, died, the relation of a client and advocate comes to an end, and therefore we don't know how we can produce the death certificate. We simply disclose that accused is died. Then what is the position? How it is to be ascertained that accused is died? Because that oral statement or a statement by an advocate cannot be treated as an evidence in a criminal matter. It is only a submission. Even a letter given by the advocate of the accused on record, making a statement that the relative of the accused has disclosed that he is died, and therefore I am disclosing it that the appellant accused is died, and therefore now my duty is over. But that is not enough. This is a very typical case of appreciation of evidence. In that case, what is to be appreciated by the court? When there is a disclosure about death, First thing, the advocate of the accused appellant who has filed appeal or who was appearing till date is bound to produce on record the proof of death of the appellant accused. The proof of death is, as I said, postmortem note in unnatural death or death certificate in natural death with some additional evidence that death certificate is of the same accused, same person, means affidavit of near relative. But when advocate for the accused, rightly or wrongly, it is certainly wrongly, it is selective step by those advocates, and when courts are slow and advocates are, I don't want to identify in any manner, but then that happens. But otherwise, in those cases also, it is the duty of the court to issue notice upon the appellant accused, the victim, and to call the nearest or the concerned investigating agency and to ask all of them to produce on record based evidence or evidence which confirms the dates of the appellant beyond reasonable doubt on record, either in form of postmortem note or death certificate and a statement on oath by his near relatives that yes, he died. The appellant accused died. In that case, that appeal would be abated, means now when person is died, his heirs cannot be convicted or sent behind the bar, matter is over. Therefore, it is so serious that mere disclosure by somebody on record that appellant accused has expired or died, it is not sufficient to put an end to criminal trial, the appeal. How basic rule of evidence or basic rule of appreciation of evidence would then work? Previous slide was disclosing rules, basic rules of evidence. Now I am explaining basic rules of appreciation of evidence. Firstly, Statute-like Evidence Act and Code of Criminal Procedure, so also Negotiable Instrument Act, have laid down the basic rules for the appreciation of various evidence. Judiciary has also played a vital role in clarifying the rules of appreciation of evidence on the points where statutes were silent. Rules of appreciation of evidence laid down by judiciary does not have universal application. It needs to be applied in the light of facts and circumstances of each case. And courts have been granted sufficient discretion in appreciation of evidence to do justice in the case pending before it. So there is no hard and fast or strict rule so far as principle or concept of appreciation of evidence is concerned. But some of the statute provides the basic principles. Even judiciary also played a role to decide it. But what is good evidence before a couple of years or months or days or decades may not be good today. And therefore, it is not static. It must be used with facts, with reference to facts and circumstances of each case. And it would be not static. It would change by passage of time. But yes, there is discretion with the judiciary, the judges, to consider that how particular evidence is to be appreciated. But that discretion also requires to be used judiciously and not by way of personal whims or other reasons. And this appreciation of evidence would convert the ignorance on day one after collection of facts by the investigating agency into knowledge in the form of final order, wherein all these steps would be taken care of during the trial, that is collection of facts by investigating agency, then it is producing it before the court, framing charge by the court, adducing evidence by both the side, weighing evidence and applying different alternatives and precedent and probabilities, and then final decision, a conclusion or finding that yes, particular accuser has either committed the offense or not committed the offense, whatever the fact may be. So ignorance would convert into knowledge through appreciation of evidence. This is the basic concept or issues so far as appreciation of evidence is concerned. Otherwise, there will be a... Now, whether this text file is visible, any one of you can confirm it?
Yes, sir.
This word file is visible, no?
Yes, sir.
Okay, fine. And how much time is there now with us?
Sir, 5 minutes.
5 minutes. Okay, then let me just make it clear. Okay, so now this appreciation of evidence, for your benefit, I have prepared this lecture, taking all these subjects for discussion or for explanation, summary, introduction, evidence, different kind of evidence in criminal cases, mode of evidence, and so on. All these subjects are there. But now, as only 5 minutes are there, it is very difficult to read all these subjects, all this paragraph one after another. It is almost 35 pages. Therefore, now before coming to the next point or next step in such seminar, webinar, let us just recollect few basic principles in our life. Never underestimate your competitor. Expect the unexpected. Think there must be a better way. If we cannot direct the wind, then we can certainly adjust our wind. If you want happiness for a lifetime, learn to love what you do. One man can make difference, and you may be that one man. Best way to make your dream true is to wake up. React now, because time, tide, and opportunity waits for none. If you light a lamp for someone, it always brightens your path. Cultivate hope for everybody. Neither fire nor wind, neither birth nor death can erase our good deeds. I think then now provide shelter for others, sign whatever the weather may be,